Hi, this is your host, Andrew Raffel, the founder and CEO of Baintree Wealth Advisors. And I want to welcome you to the Your Wealth and Beyond podcast, a show that was created to help you simplify the financial world and to ensure that you're living your best life now and in retirement. Each show, we're going to be bringing on experts that are going to help you build wealth and, most importantly, find purpose in what matters most. Estate planning. We've all thought about it, but the majority of us have never done anything. We'll get to it next year. And one of the reasons we've never done anything is because estate planning deals with us realizing our invincibility. And in most cases, it just takes a tragic event or a major milestone before you'll get your ducks in a row. And that's not a good way to plan. I don't care where you are in your life cycle, just starting off or getting closer to retirement. So today we wanted to introduce you all to Kirsten Howe. She has spent over 20 years as an estate planning attorney, helping individuals and families get their estate plan in order. She has made it her life's mission through her company, Absolute Trust Counsel, to educate all of us on the pitfalls that people make when they don't plan and what you need to do to get your estate planning house in order. We go through everything from what it means to do nothing, the difference between having a will and a properly executed trust. We even dig into the benefits of making sure your beneficiary forms are updated, and also talk a little bit about digital estate planning, as well as if the estate tax laws change, some of the things that you can do to ensure that you keep more of your hard-earned money in your pocket and less to Uncle Sam. So without further ado, my episode with Kirsten Howe on proper estate planning strategies that you can use today. And welcome back to another episode of Your Wealth and Beyond. Super excited to introduce you all to Kirsten Howe. Kirsten, how are you today?
I'm just great, Andrew. Thank you. Thank you for having me here today.
Yep, I am super excited of all the items we're going to go through today. And, Kirsten, when we think about estate planning, why do you think so many people put it off or think of it as almost as horrific as going to the dentist? With you spending your entire career working on this side, why do you think that's the case?
There are a lot of reasons. One being that it requires you to interact with an attorney, which, we are not very pleasant people to interact with. But all kidding aside, it's just in general, as with many things in life, although it is important, it doesn't feel urgent. And we feel as though, I can do that later. There's plenty of time. I can do that later. And we're going along, we're doing our jobs, we're raising our kids. We have lots of things that urgently require our attention. So there's that. And as you alluded to, just the idea of sitting down and thinking about being gone from this planet is hard for some people. So, there's lots of reasons, mostly emotional and irrational.
Yeah. And I think a lot of times it takes an event, something happening, and a lot of times it's unfortunately a tragic event. I lost mom and dad, or somebody's incapacitated. For that person, no matter where they are in their life cycle, where they are in their age, to think about, the invincibility, at some point I'm going to need things and need things handled. And, part of what we'll go through today of having a proper estate plan, sometimes the simplicity and the ease. And a lot of times it takes kids to see how easy it was that mom and dad, they did have a proper plan in place, and now it's time to get that done. So we'll dig into all of those things. But, overall, when we think of estate planning, what does that mean to somebody? And whether we're just starting out in life, we've got kids, or we're getting to retirement, like if somebody's going to ask you, Kirsten, what's estate planning mean? What do we tell them?
Well, what I say is estate planning is you planning what you want to happen in the event you become incapacitated, or in the certainty that you die, because believe it or not, eventually we all will die. And we are trying to make things by doing estate planning, we're trying to make things as easy as we can. Mostly this benefits your family. It benefits the people who you leave behind, and it benefits the people who have to step in and help you if you do become incapacitated. So we're trying to accomplish what you want rather than what the law thinks you might want. We're trying to minimize expenses. People who don't do estate planning, their estates tend to be very much more expensive. We're trying to minimize taxes. There are plenty of tax planning opportunities you can avail yourself of by doing estate planning. And one thing that's really important is we're trying to keep everybody out of court. Failing to do any kind of estate planning can land your family in court. And that's always very expensive and stressful because, again, it involves attorneys, and we don't want that if we can avoid that.
Right. And we'll talk about that 4-letter word of probate later in the show. So you really, there's two options: doing estate planning or nothing. So, and a lot of people, even when we're working with clients, unfortunately, a high percentage, it's like, hey, we thought about doing it, we're going to get it done, but they just haven't done it. So you mentioned the loss of control. So for a listener that hasn't done anything yet, what does that actually mean to them if something were to happen? And I know it varies per state. So maybe we can just talk generally of, in their mind, they're thinking, well, I'm married. All these things are going to happen here, or I've got mom or dad to step in. But what does that actually mean if they don't have anything, meaning no will or potentially a trust or power of attorney? What does that mean for somebody?
Right. So what will happen is going to depend on what the event is. And the event is either going to be incapacity or death. If you don't have any estate planning in place and you become incapacitated, your bills can't get paid. Your doctors don't know who to turn to for decisions about your care. Your family will end up having to go to court in California. I'm from California. In California, we call that a conservatorship. Other states call it guardianship. In order to just be able to step in and help you when you could very easily have avoided that by, executing a few simple documents. So those are the issues on incapacity and death. Without doing any estate plan, first of all, your estate will pass according to your state's rules of intestacy, which determine who inherits when there's no written plan. And you might not like that plan. I have a lot of clients. Here's a real easy example. I have a lot of clients who, in their later years, they have a second marriage, but they're really not married. And they do that for financial reasons. Lots of people do that. Now, if those folks were to pass away without a written estate plan, that person to whom they are not married would get nothing, would not be able to continue living in the home that they had been living in together with the person who died. And it's just very, very complicated. And people think that because you're married, your spouse should be able to handle things for you. That's not true. Just being married to someone doesn't give you the legal right to step in and start doing things with their assets or even making healthcare decisions. You've got to have it in writing if you want anybody to be able to help you on incapacity, and if you want any kind of control over what happens after you die.
Right. And in the where we've seen even husband and wife, we've seen a lot of issues is the way that a home is deeded. They ultimately, one might have purchased the home prior to getting married. The home is titled as sole and separate or an unmarried individual. And they get married, they don't change it. And then one happens to pass away without proper estate planning. Well, a lot of times you would see that the surviving spouse has to go through probate in order to get that property in their name. And then, as you stated, there could be a whole bunch of other things that happen because it's public now and with the court. So it just makes it where there's not so much hoops to jump through, but time and money. And these are the last things you want to worry about when you just lost your significant other.
Right. That's it. And that's a really excellent point. Planning ahead makes it so much easier for the people that you leave behind. I just can't emphasize that enough.
You probably hear it time and time again, but like when, as a comprehensive planning firm, the firm that I own, Bain Tree Wealth Advisors, that one piece, that estate planning is one of the most important pieces, no matter how good you do anything else. If we don't have that protected, then the whole house could come down. And we have it, as a client does work with an attorney and we help them through that process. It's like that. You can feel the weights lifted off of them, right? Once they've signed everything, and we'll go through how it's fully executed. But like, don't you get that a lot? Like, oh, Kirsten, I feel like this weight has been lifted and this peace of mind that we've got things in order.
Oh yeah. Yeah. Very, very frequently, especially, with married couples, at least one of the spouses will say, even just at the end of the planning meeting, they haven't yet signed the documents. They will say, I'm so glad we're doing this. It's such a relief. That's the word that I hear very often. So it weighs on people. And like you said, sometimes it takes a crisis of sorts to make them take action.
And one of as we hear, hey, why haven't you done anything? Especially younger clients, they're just like, we don't know who to put as our executor or the successor trustee, or who's going to be the guardians of the kids. Like, and that's not a great answer. I tell them, right? It's, yeah, you may not have 100% definitive, this is what I want, but if you don't have anything, like you mentioned, now the state decides. So you make that decision. Do you want them, or do you want your family that can be, of course, as we'll talk about, revocable, can be changeable as long as they're sound mind and body. But how have you have somebody that they want to move forward, but then it's like, I don't know who I want. What is your advice that you give your clients in that situation?
That decision about a guardian for the children, the person who would step in and become the parent if something happened to the parents, that often is a stumbling block for young families. I hear that quite a bit. And I just tell clients, with respect to guardianship and all of the other roles that they might have to name, a successor trustee, an executor, what have you, I talk about the qualities that the person should have, the qualities that they don't necessarily have to have. And I say, you're not going to find a 100% perfect person. You're not going to find you. That person that you name is never going to be you. You got to do the best you can. And leaving that spot blank in your estate plan is just not acceptable, because especially something like a guardianship, that's a court proceeding. We can't avoid that. And you can have families duking it out in court over who should be the guardian if the parents haven't expressed their preference in writing. So you have to do the best you can.
Right. And a lot of times we'll have the medical be different than the financial. And that's something that for a lot of families, they, maybe they have a son who's in the medical profession, but they want their daughter who handles more of the finances. So there are ways to structure that, listeners, where it's not an all or nothing. And as laws continue to change with HIPAA and the privacy and those type of things, it's so important to get those ducks in a row.
Yes, you can have different people in different roles. The person who you select to raise your children doesn't have to be the person who manages their money. Those are two different skill sets, and we often do that. So, yeah, the roles can be divvied up.
Okay, so let's think in terms of, we've got somebody, a family, they're ready to do something. Now we go through options, right? And this is where I want to have you break down what are the options. And when I say break down, looking at, okay, we can do a will, or does a revocable living trust make more sense, and incorporating the pour over will into it. So when you're sitting with a family and trying to determine the best action for them, how do you teach them and educate them and provide them the guidance? And I know every situation is different, but if we wanted to talk high level of the difference between the two and where it fits appropriately.
So I practice in California, and we here have a notoriously cumbersome and expensive, usually, probate process. So I guess this is where that four-letter word comes into play. We almost always are advising the use of revocable living trusts in order to avoid probate, if for no other reason. So we talk about the advantages of avoiding probate. The planning on the part of the client isn't all that different from an estate plan that has only a will. When you have a revocable living trust, and I know revocable living trusts are also used in your state, Arizona. When you have a revocable living trust, it says all the things that you would say in a will. It says who gets your stuff when you die, but it also, A, avoids probate, which is very, very important, and B, it also is something that can protect you and your family if you become incapacitated, which a will does not do. A will is a document that is of no legal effect until the day you die. So in my practice, it's generally pretty straightforward unless there's no possibility that the client is going to have a probate-sized estate. If we can avoid probate without a trust, that's fine. I'm happy to do that for my clients, but that's pretty rare. That's pretty unusual. The threshold for probate here in California is 166,250, I believe. So,
And I think Arizona, it's like 75,000 of assets that are held.
yeah.
And so, and that's where I think what we've seen over the years, a lot of people get confused. They confuse the death tax, right, which right now is well over $1 million for each of us. And towards the end, we can touch on that of where we think it, if it does change, what that means. But they confuse that with probate. And so, I don't need a trust. That seems so comprehensive, and I got to get a bank involved in all these things. So the notion of probate, and you hit it on the head there. It's, the death management, but also that lifetime management and having things go smoothly. Obviously, when you pass away, you want it to go smoothly. And most people, if you ask them, do you want to get stuck in court and have family potentially fighting, or to go the way you want with no fighting potentially and, seamlessly, they're going to choose the latter. But when it comes to that lifetime management, a lot of times they don't understand what that would look like unless they've been through it. So I think that's such an important component of having, nothing at all, or even just the basic will, is that's upon death, what happens if we cover that incapacity and we need these assets to be used to take care of the individual.
Right. And there's a lot to the issue of incapacity in my experience, and my belief is that we probably, as estate planners and as clients, we may not focus enough on incapacity given the statistics. We can't avoid the fact that dementia is a big deal in this country. The statistics are depressing, but planning a little more carefully for our own incapacity, I think, is very important nowadays.
Right. Especially as we're living longer.
Right.
And with that, physically, we may be there, but then mentally, the mind, and it's unfortunate. I've lost several of my grandparents, two of them that, had that cognitive impairment and dementia. And it's very sad. As we've been working, and I'm sure with you too, as clients that we've been working with for sometimes almost close to 20 years, you can kind of tell when they start losing the cognitive ability. Sometimes it's slow, sometimes it's faster.
Yeah.
And those are the things that once that happens, we as planners and you as attorneys, there's only so much we can do at that point. But we have to keep that the red flag up and making sure that the trusted family is there to help them through all of those things. And it's hard to fix it when it's already broken, when you can't go back because they're mentally not there.
Right. That's exactly right. Sometimes the very first thing that we do when we meet a new client who needs to do planning, and there's a concern about dementia, is we get really good powers of attorney in place so that whatever happens, we still can proceed and complete the estate plan or whatever the project is that they want to undertake. Dementia doesn't mean incapacity. So dementia can be a very long, gradual, as you said, Andrew, path. So early dementia is not incapacity. It isn't the same. It doesn't mean you can't do estate planning. And I hope that listeners out there pay attention to that sentence.
And so when we start educating about the value of a trust, and it depending upon somebody's milestones in life, it's not just for somebody who's accumulated all these assets, as somebody's starting off and they have a family, or they're into the phase, the family's getting older and they're, climbing the corporate ladder, and, they're in their 50s or obviously in their 60s or 70s. But what does it mean to have a revocable living trust?
Okay, so the trust is a concept, an abstraction, a relationship, if you will, between three people. There's the trustor or the grantor. That's the person who moves assets to a trustee to hold those assets in trust. And so the trustee is the second person. Their job is to take care of the assets and do what they're supposed to do. And then the third person is the beneficiary. The trustee's job is to manage the assets, follow the instructions for the benefit of the beneficiary. That's every trust has those three things. When you have a revocable living trust, which is the standard issue document that we use in estate planning, you are all three of those. You are the grantor because it's your assets. You are giving them to the trustee, who is also you, and you are holding all those assets for your benefit. So it kind of sounds like nothing really has happened, but legally a lot has happened. Now you individually don't own those assets, and that's how we avoid probate. You only have to go to probate court when a dead person owns property. But if a trust owns the property, it's not owned by a dead person, we don't have to go to probate court. So having a revocable living trust means you have to plan out what you want to happen, either on your incapacity or on your death. You have to plan out who is going to do all these things for you. And then you have to plan which assets are going to be held in this trust. And that part is critical, and it's maybe the one that clients tend to forget. They tend to lose their focus when it comes to that. I've had lots of clients in the past, unfortunately, who did an estate plan and then they died and they had a trust, but we found assets that weren't in the trust, and we end up having to do a probate anyway, even though they did an estate plan in part to avoid probate.
Right. And that's the area where we see, somebody brings in a trust and it's beautifully written. They spend thousands of dollars on it. But then we ask, is it funded? And they look at us like a deer in the headlight. What does that mean? I thought it's all in there. And then you have to explain to them, you've created this instrument, but if it's still owned by you, and a lot of times we see this with homes, a lot of times, it just had a situation. There's a lot of the refinancing going on right now. So for whatever reason, the banks want the home, if it's in a trust, which again, as you stated, you and the trust are the same entity in a sense, right? But they take it out of the trust. So now it's back in their names. And so then the banks are like, oh, we did the refinance with the title company, and they're done and they move on. So the listener understands that if you have a beautifully written trust, well executed, but if the home is in your name and you pass away, it is not in the trust, and thus you would have to take it through probate to get it into the trust.
That's exactly right. People often think that, usually when you create a revocable living trust for a client, the last page of the trust is going to be the schedule of assets. Those are the assets that we intend to be in the trust. Just listing them on a piece of paper doesn't make them trust assets. You have to actually do something. So typically the attorney will put the real estate into the trust. That's what the attorney does, right from the beginning. But as you said, Andrew, things happen. Assets wander away from trusts, and it's very often the case that in a refi that happens. Also, you sell your house and you buy a new house, and people forget about that. When you buy that new house, it needs to go into your trust. Other assets also, you actually have to do something. If you want a bank account to be in your trust, you have to go to the bank and fill out their forms, and they'll take care of it for you. It's not difficult, but you have to do it.
Right. And on that note, because we get a lot of questions, what we try to educate them prior is if, and we provide them from the attorney a certificate of trust, which basically gives a more of like a summary of everything. It's 4 to 5 pages usually. But what we always remind them is, hey, you may get somebody in the bank that's going to ask you for your tax ID. And this is where this confusion can start. They're thinking, well, what's my tax ID? And so one of the things, as you mentioned, is the trust. When they create it, they are the trustor and the trustee. So the trust is them. So it's ultimately their social security number. Nothing changes with regards to that until it becomes irrevocable, which is a whole nother thing. So do you get that question too sometimes as, hey, the bank's wanting to know what the tax ID is and making sure the client understands why it's their social?
Right. Yeah. And as you pointed out, we always create a certificate of trust, which is kind of like the client's, driver's license for their trust. It's their ID card. And it says right on there, the taxpayer ID number for this trust is the social security number of the grantor. But yes, we get that question a lot.
And the whole point when you say revocable, does that mean that as the trustor, the creator, that they have the ability to make changes to the specifics within the trust?
Yes, the revocable trust is revocable. It's amendable as long as the grantor is alive. Oftentimes in California, at least, we create joint trust between husband and wife or married couple. And oftentimes, if one of the spouses dies, an aspect of the trust becomes irrevocable. A portion of the trust becomes irrevocable. But yes, just for an estate planning perspective, your trust is always revocable and amendable by you, as are all the other estate planning documents.
And that's where we try to also hit it head on, where they get confused if they buy a new home or open up a new bank account. In their mind, they're thinking, I got to change the trust. I got to call the attorney. So we try to let them, and through the education process, let them know that that's not fundamentally an amendment to your trust. An amendment is when you want to change a successor trustee or change the beneficiaries or other items. What you need to just make sure of is that asset, if it should go in the name of the trust or be owned by the trust, that is properly titled that way, or sometimes beneficiary is the trust itself.
Right. That's a really excellent point, Andrew. There's a lot of confusion there. I get calls from people saying, well, we've changed all these bank accounts now, so we better update our trust. No, you don't need to. You just need to make sure everything's correctly titled.
And then if you say you have a client where you've created the estate plan in California and then they move permanently to Arizona, what do you usually recommend somebody who's created a trust in one state moving to another? Do they have to make changes to the trust, or is it just to maybe the power of attorney type documents, the living will?
Well, generally speaking, a trust that you create in one state under the laws of that state is a valid trust in any of the other states in the country. So I'm not as concerned about the validity of the trust. And for the most part, your will also is going to be valid in any other jurisdiction. Where you can get into trouble is when you move from a state like California to a state that is not a community property state, if you're married. That could possibly cause you to want to update your trust, taking into account the laws that apply to you now that you've moved. Generally, when I have clients who move to another state, I tell them you should check in with an estate planning attorney in that state and just make sure your trust is going to be okay. But the thing that you typically will for sure want to change is your power of attorney and your healthcare directive. Those two estate planning documents are very state specific, and you would want to have one that's written under the law of your new state.
And in conjunction with that, I would assume too, the living will, which protects if you were in life support, terminal condition, things like that. Would that be also, would you want to make sure that it's updated for the state that you live in?
Yes, absolutely.
And that's, again, confusion. People are like, I have a will. No, they have a living will. And so
very different.
Yeah. So just quickly go through to somebody on that note. What does the living will do, and how does it incorporate with the protection of their wants and wishes?
Yeah. A living will typically will specify things like the kinds of care you want to receive again, this is if you are unable to communicate, somebody else has to make these decisions for you. So you have put down in writing what you would do, what you would have them do. Kind of the general, I guess, bifurcation is I want to be kept alive no matter what, versus, if the doctors say it's hopeless, I'm never going to come out of this persistent vegetative state, then please don't administer life-sustaining treatment. If it's not meant to cure me or not meant to provide comfort to me, if it's just meant to keep me alive for no purpose, I don't want that. So those are the kinds of things that a living will would address.
And it's amazing that the story now is well over 15 years old, but people always remember the Terry Schiavo case.
Yeah.
Terry Schiavo. Yeah, it's amazing, and so that, that I remember that. And that was obviously hit home with a lot of people, whatever side somebody was on, but ultimately she didn't have the control, or the family didn't, because, so young at the time that they didn't have things in order.
Yeah.
So you mentioned earlier, and this is so many second marriages or partners, or third marriages, right? But let's talk about where estate planning really, really makes sense. So you had mentioned the house situation, and we have, a lot of clients that have either been remarried or have a partner now, and they live in a house together, even though one owns it in the mindset they want that house at some point to go to their biological children, but they don't want their significant other to be kicked out if something happens. So walk through why an estate plan would be so important to spell that out, so that there can be no, in a sense, contestment from his or her family in trying to kick out the survivor.
Right. So even if the couple is married, but especially if they're not, the house belongs to the one whose name is, on the recorded title, on the last recorded deed, and it will be subject to that person's estate plan, whatever that is. And if they don't have an estate plan, then we're again talking about the laws of intestacy, which is whatever the legislature 150 years ago decided this would be a good estate plan for everybody. That might not be what you want. And one thing about second marriages, third marriages, is that people tend to come to the marriage with assets. And those assets that they bring to the marriage are considered separate property if we're talking about a community property state. So even if the couple is married, if that home was a separate property asset and there's no estate plan, that separate property asset is going to the children, at least in part. And it might go partly to the spouse, it might not, depending on the laws of intestacy. Then you've got, surviving spouse and stepchildren in a bit of a tangle over, should surviving spouse be allowed to live here? Should surviving spouse pay us rent if we're going to let him live here? These are problems that are so easily avoided by just writing it down. And we, on second marriages, we have to go into all of that. What happens if you die first? What happens if you die first? What about this house? How long does the surviving spouse have to move out? Or does the surviving spouse get to live there? Does the surviving spouse get to sell the house and buy another house with that money? There's so many conversations we have to have in that context of just generally what I'd call a blended family.
Right. And then that leads into the beneficiary form. And this is some of the most misunderstood in how it revolves around estate planning. And, we're big into these beneficiary form checkups, because here's where the issue arises, right? Is where somebody might have a great estate plan, but a certain asset has a beneficiary listed. And that a lot of times it's Kirsten, it's IRAs, it's life insurance, sometimes annuities. So let's talk through on the mistakes people make on that, and how the beneficiary form in most cases supersedes any estate planning, and what they need to do to make sure that everything's aligned together.
Right. So there are, specific types of assets that pass on death by way of a beneficiary designation form. And that's a form that you fill out and provide back to the financial institution that has that asset. In that category are IRAs, 401ks, all those retirement type assets, 403bs, 457. Also in that category are annuities, even if they're not retirement assets. A lot of people have annuities, and those oftentimes will have a death benefit. Also in that category is life insurance. And I think everybody understands that life insurance is something that you've got to tell the insurance company who's getting this when you die. That's just part of applying for the policy. And, especially if you talk about, say, the retirement assets, for many of my clients, the retirement asset is the biggest or second biggest asset. They have a home and they have a big IRA or 401k, and the rest is pretty small. So if the beneficiary designation doesn't line up with the rest of your estate plan, if it doesn't work the way the rest of the estate plan does, it could be very bad. And the beneficiary designation form that you submit, the most recent one that you submit to the company, is the one they're going to follow. They have no choice. It's legally binding upon them, even if it makes absolutely no sense.
And if you think about it, listeners, and let's talk about that. Let's say you've got, you're married, second marriage, first marriage ended a while back, but time and time again, we see the mistake. There might be an old life insurance policy with the ex-spouse on there. And inevitably, it's a battle, right? No matter how they have their estate plan, if there's a life insurance that has an individual listed, or a lot of times if they're not married, young, they've got mom or dad listed, and then they get married and they forget.
They forget to change it. Yeah.
Yeah. You've seen where, a lot of times the family's like, okay, and they can disclaim it. But how many times have you seen they're going to battle and fighting, and now the surviving spouse doesn't get what was actually, in most cases, wanting the intention of that person who died? Was it to go to their spouse or to go to their kids?
Yeah. And especially with something like a retirement account, an IRA or a 401k, those have a tax burden on them. So doing this, what we call after death planning, you mentioned, Andrew, disclaimer, that can result in a really harsh tax result. So you really don't want to leave that to the after death cleanup crew. You want to plan ahead. It's almost always so much more trouble and expense to have somebody come in and clean up after the fact than to plan ahead.
And then the other provisions, and this is more on the financial end, but in regards to like IRAs and how the tax treatment of those are structured. In most cases, unless there's a reason, what we do working with the client and the estate planning attorney is we're big proponents of having a retirement account list the beneficiaries out specifically in percentages. And with that, it gives each of them the ability to do what they want to do and create what's called an inherited IRA. Now, the laws have changed. You can't stretch it out over your lifetime, but you still have some pretty good benefits within a 10-year rule. And this is where a lot of people have a trust in place, it ultimately can go the way they want, but there are going to be some hoops to jump through to make sure that they covered a couple of points to make sure the trust was legal and valid. But then, Kirsten, the one issue is whoever the oldest beneficiary is, they have to use that person's age to determine things out. Now, that changed most of it because of the fact that this law changed, but it's still, would you be, unless there's a reason, special needs or children or minors or the drug issue that they don't trust the kid, that they should list individuals on retirement accounts rather than in a living trust?
Yeah, it is better. It is better if you can, but it's kind of a balancing act because, as you pointed out, there are certain people who we want to benefit from our retirement assets who maybe shouldn't get their hands on that money directly. They might be minors, they might be special needs people, or they might be just, irresponsible. So the way you control what happens is you leave your assets to a trust, and the best tax result is leaving it to an individual if it's a retirement asset, that's for sure.
Yeah, so my daughter who's 14, we have a living trust, of course. I'm not the cobbler with the kids, no shoes, the whole thing. But But we have our trust, like for right now, my 401s and IRAs and Roths, they have right now my spouse number one and vice versa, but we have our trust number two. And that's just because we have certain provisions within the trust to protect my daughter who's 14 in a sense from herself. And so those reasons, also, like you mentioned, so important on the special needs. That could be a whole episode in itself of making sure that heir, that beneficiary who's maybe getting state or federal aid, still has the ability to use those assets that were intended for them, but to keep it out of their estate so that they don't lose those benefits.
Right, right. And, as your daughter grows up and demonstrates that she's responsible, you can change that beneficiary designation and you can put her name on that second line rather than your trust. And that's something important to keep in mind also.
And the estate tax. So previously when it was, 10, 20 years ago, when it was a couple million for each, what type of planning, well, let's move forward. If they change it back to some lower numbers, is there any type of estate planning that should be looked at this year in lieu of that, of potential changes of this, the death tax is what we call it?
Right now, we don't have many people who have to worry about estate tax because the exemption amount is so high. It's $11.7 million per person. Now, I'm talking about the federal estate tax, and there are states around the country that have their own estate tax, and that's a whole other deal. But we do know that number is going to go down on December 31st, 2025. It will go down to 6 million or so. So we have people who definitely need to pay attention to that number, and they ought to seriously start thinking about what their plan is going to be. It's also possible that Congress could lower that number earlier, and there's talk within the Biden administration, of course, of trying to accomplish that. Now, the president doesn't get to do that. He has to have Congress do it, so we'll see. But a few things that are easy for people to do, I don't know if this is what you want me to talk about here, but you might start making gifts. You might, if you can, if this makes sense in your family, we each can make a $15,000 gift every year to as many people as we feel like. And there's absolutely no tax consequence there. So, people who have a small estate tax problem might be able to reduce the size of their estate by just coming up with a gifting plan. Leaving assets to charity. Anything you leave to a charity doesn't count toward your estate tax. And
so on that note, if you had separated out an IRA, it's $500,000, and you wanted it to go to a charity, Phoenix Children's Hospital, let's say here in Phoenix, would that be then, if it's 100% going to the charity, or in this case to the entity, does that would not be part of the inclusion of net worth that's calculated for the death tax, for the estate tax?
It would be, well, now I'm getting too technical. It would be part of the estate, but you get a deduction for whatever you give to the charity. So yeah, when we go to figure out what is your estate tax, that amount doesn't count. And the nice thing about, I'm really glad you raised that. I mean, the nice thing about leaving money to a charity out of an IRA or out of a 401k is that the charity gets all of the money because charities don't pay income tax. Whereas your family members who get your IRA or get your 401k, they're going to pay income tax on the money. So if you're planning to do charitable bequests, take a good look at, can we do this out of an IRA or a 401k?
Great point, because if we have a certain amount of assets and we know we want X to go to the charity, the rest to go to the kids, and let's say there's after-tax assets, real estate, right now the law, and they could change this in the future, but the law is upon somebody passing, there's a step up in basis on those assets, meaning the kids can get it and sell it and not have to pay any capital gains. So you bring up a great point there. Is it's so important on the planning side, if you have X amount of dollars that you want to go to a charity, is maybe using the retirement money or something that is going to be taxed upon somebody who receives it, giving that to the charity, to the foundation, and using other assets. So that's a great planning. We've done a lot of charitable remainder trusts, and I know that's probably too technical for this show, And then maybe we'll get back to the ILITs. That'll become more important as most people are not at that 22 million right now. On the gifting, this is something where we are at 15,000, but sometimes it's confusion, right? So if I have I'm a grandparent or, I've got children, so I can give 15,000 to, let's say, my daughter. And if she's married, can I gift him 15,000 as well?
Yes, you can. And your wife can do the same thing.
So we can gift ultimately to that couple, my daughter and her future husband. Hopefully we like him. Jury's still out, right? But
Yeah.
but ultimately,
Which is only
60,000.
14.
That's right. She's not allowed to date right now. But so if we go over that 60, what does that look like? Is it allowed? And how would somebody go about showing that to the IRS? Because I get a lot of questions on that. Well, I can only do the 15 and we want to gift 100 and maybe it makes sense. What does that look like as they're, in a sense, utilizing their lifetime gift exemption?
Yeah, that is such a good point, because we so often get clients say, oh, no, I'm not allowed to give that much. That is not true. You can give as much as you want. You can give everything. The question is, what is the tax impact of what I give? So if you give a $15,000 gift, no tax impact whatsoever. If you give $15,000 plus one, you are going to file a gift tax return in the year that you did that, and you're going to tell the IRS, I made this dollar gift, this gift that is in excess of my $15,000 allowance every year. That's just reporting. It's a gift tax return. It's a Form 709. You file it with your income tax return. You're just reporting it. You don't get taxed on it. And the IRS collects all of those 709s. And so when you die, they know exactly how much you have given away. And that is subtracted from your estate tax exemption. So earlier I mentioned the current estate tax exemption is $11.7 million. If you die this year and over the course of your life, you've already given away $300,000 that you had to declare to the IRS, now you only have $11.4 million left to leave without paying estate tax. But I find that people really are confused about that they get kind of panic stricken when you say, no, you can make larger gifts. It's okay.
Right. No, totally. And I think there's probably going to, depending upon what they do or what we're foreseeing them to do with potential changes, you'll probably see a lot of advanced estate planning happening. You'll be very busy towards the end of this year and into next year as people are going to try to take advantage of whatever the rules are, the law is today, and assuring that they can do everything they can. And most people want to keep more money. They're okay with paying taxes, but more money in their pocket and less if they can plan accordingly.
Yeah, absolutely. I think you're right.
So we've gone through quite a bit today. The last thing before we end, and we probably could banter back and forth for another couple hours, although I don't know if our audience would.
No, they couldn't stand it.
But so digital estate planning, right? It's one that is still, I think, in its infancy. But we've seen and heard the horror stories with our lives now digitally, whether it's Facebook, we've got a Gmail account, we've got these assets, a box folder that has all of their secure stuff in it. What really can we, and just high level, but what can we start looking at and preparing for to incorporate the digital estate planning into our overall planning?
That is a really great question. You want to make sure that you have in your written estate plan authorized somebody to deal with your digital assets after you pass away. So, typically if you have a revocable living trust, you're going to have a provision in that trust that says, my trustee has legal authority to manage and access my digital assets. And so that's a start. The platforms themselves have their own rules, and you can't override their rules, because when you signed up to use Facebook, you signed up to use Snapchat, all those things, you agreed to those terms. So you can't get around that. But a lot of them have some sort of online place where you can go and tell them what you want to happen if you die. If you want your representative to be able to access your email, if you want them to be able to create a memorial page on your Facebook account. You can go online and use their online tool. Each one of them has it. And that's something that probably very few people know about and very few people do.
And then another could be using these password software programs like a LastPass or 1Password, where ultimately the spouse or the child may have the ability to get to the master password. Maybe it's in a safety deposit box, but that can be also, in a sense, more of a lifeline than somebody writing down a bunch of passwords on their pad of paper, or even an Excel document that gets, first off, you've got some risk on that more so than I think on these password protection programs that have more of the encryption built in. But that could be a way too to offset so that somebody at least could have access to things immediately.
Yeah, that is a very good point. Probably most of us have a handwritten list of passwords that makes no sense to anybody else. There's a better system.
So, I think listeners, we've gone through a lot today. Kirsten, the one thing I think we hit home on several times is the need to do something. Don't do nothing, because nothing is going to mean you've got no control over what your wishes are.
That's right.
No better time we talk. And I think too with, Corona and COVID, and, you probably saw things over the last year where people were more in tune to getting things in order because of what's been happening, the uncertainty of the world that we faced since last March.
Well, yeah. And I think that goes back to my original point, which was everybody gets that doing the planning is important, but it doesn't feel urgent. When we stepped into late March last year, suddenly it became urgent for a lot of people. And yeah, we got slammed. We had a lot of work to do, helping people do their estate plan.
Never a bad thing. You're recession proof in a sense, especially when they change the laws.
Yeah. In the good times, they do planning. In the bad times, there's still the death work. So,
well, and I've really enjoyed our conversation, and I love what you and your firm are doing. And this will all be in the show notes, listeners. But Kirsten does a podcast almost religiously with these type of topics and bringing on guests to help educate you, the listener, on all these things that we talked about today, and then drilling down on a specific topic. So you're doing awesome stuff there. And I know you also tie it into some Facebook Live stuff. So you guys are continually trying to push out good information to help people, whether they become a client or not.
Well, thank you. Yeah, that's my mission, is to educate the world.
Yeah, there's so much misinformation out there, and that's the key. So you try to break it down. And so on the show notes as well will be the ability for people to go to the podcast, your website. You've got some great downloads that they can have, as well as to your social media. So, keep doing what you're doing. We need more and more people out there that are helping to break things down and help push people forward to make the right decisions.
Yes, and thank you as well for what you do. It's really great. This podcast is really great. You've had some very impressive guests. I'm thrilled and humbled to be among them.
Well, awesome. We appreciate it. And I hope that siren meant whoever they're going, that they had their estate plan in order. Keep our fingers crossed.
Yeah, sorry about that.
No, that's great. So, Kirsten, thanks for joining us. Really appreciate it. Listeners, all the show notes will incorporate all the things that we talked about. Key component here is planning with a purpose. Don't wait. Get it done now. Stay tuned for another episode later this month of Your Wealth and Beyond. Happy planning, everybody.
Thank you.
Thank you for joining me for today's episode of Your Wealth and Beyond. To get access to all the resources mentioned during today's podcast, please visit vaintree.com/podcast. And be sure to tune in later this month for another episode of Your Wealth and Beyond.
Investment advice is offered through Baintree Wealth Advisors, LLC, a registered investment advisor. Insurance and annuity products are offered separately through Baintree Planning Group, LLC. Baintree is not permitted to offer, and no statement made during this show shall constitute legal or tax advice. You should talk to a qualified professional before making any decisions about your personal situation.